Welcome back to the Law and Crime Network. I'm Heather Hansen. We are in a break in our one trial in Ohio, but we are also waiting for the judge to give an Allen charge in the Tex McIver case. I have three fabulous guests here with me. Jonna Spilbor is here with me in the studio. She's a criminal defense attorney. Nicole DeBorde, former prosecutor and currently a criminal defense attorney. And Latonia Hines is here with me. She is actually there at the courtroom. Latonia, thank you so much for calling in with us. Tell us a little bit about the mood in the courtroom right now.
Well, everybody, all the people who've been here for the last few days of deliberation have still been here. A lot of the main witnesses like Danny Joe and Annie Anderson and Jay Gruber, those people have still been here. And so at the beginning of the day, everybody was kind of just sitting down and everything. But when that blue light went off, the whole atmosphere of the courtroom changed. And the blue light, for those people who aren't aware of it, indicates that the jury either has something, it's either a question, we thought verdict, but what we found out was the three questions that they had before they had this most recent question, and the atmosphere totally changed. It became very electric in the courtroom when all the attorneys returned, and then all the media started coming in.
And is there a sense of frustration that you're feeling from the lawyers there? I mean, I know I can sort of sense it from here, but being there in the room and being able to see them when they're off camera, have you seen any interactions that sort of express the level of frustration and exhaustion that these lawyers must be feeling?
The attorneys have all been very professional with each other, but as we all know, when you start hearing these questions coming through and the fact that you might be getting towards an Allen charge, it becomes very, very heated. And so what you've seen this morning has been more like law school 101 with regard to both sides doing kind of like this criminal law, criminal procedure about how things are drafted, where are we coming to with regard to the charges and intent. So that has been the level of lawyering has gone up at least 1,000%. For both sides, because each side is trying to fight for their position to go forward, so that if you're the defense, you're fighting for this to be a not guilty on these charges, and right now, if you are prosecution, getting them to a verdict, or probably even better to get to a hung jury at this point.
Yeah, you make a really good point that this is like criminal law 101. And we were talking, Nicole and Jonna, we were talking about the level of exhaustion of the lawyers, but that adrenaline gets running with these questions and the lawyering does seem to sort of go up. One of the points that Nicole made, Latonia, is that when you're in the courtroom, you can see the note from the jurors and you can get a sense of who the foreperson is. Do you have any insight on any of that, on what this jury might be doing? Is anyone giving any body language that would be helpful to our viewers to understand what's going on here?
And I'm sorry, I'm trying to position myself just so that you can be able to see. I'm sorry about that. It's always kind of crazy. No, right now, the thing that we do know is that juror number 61 seems to be the one that everybody knows about, and it's more for the reasons of being late and things like that. But when the questions come in, they come in by way of the deputy and not necessarily by bringing all of the jurors in at one time. And so once those questions come in, the attorneys start looking at them, and then they start discussing it, and then the judge discusses. He asks each side, how should we address these issues?
Yeah, it's a fascinating thing, and jurisdictions differ. Sometimes, Nicole, I'll start with you. Sometimes you see situations where the jurors come in for the question and the answer, and that sort of gives you a little bit more time to read their body language. What do you think about this idea that they've got a blue light and the deputy doing most of the asking?
Sure, it's there's always some way of notifying the courtroom and the judge that there's been a question or a verdict, and that always sends your blood pressure up. Yeah. Whenever the buzzer goes off or the light comes on, everybody starts to scramble around and try to figure out what the next step is. But all they have, I suppose, if they're not coming out and answering the questions, is watching them come and go. And are they coming and going together? It sounds like there's one juror who is just showing up late. It could be that that's the holdout. You never know. Whether or not they are a cohesive group or not is sometimes something you can tell from their actions or interactions together outside the courtroom as they congregate to come into the jury room.
I know, Jonna, you had some point on this as well.
Well, it just reminded me of something else. Let's suppose the jury doesn't come to a verdict, but they do agree they're going to be polled, and both sides are going to find out which way they were, or if they decide to talk, which way they were leaning. that is going to be instrumental in for the prosecution to decide whether or not they want to retry this case. I'm hoping the jurors will at least come forth with which way they were planning to go if they don't come to a verdict here today.
Yeah, Latonia, the judge has indicated that he's going to give the Allen charge. Do you get a sense from the other people in the room as to whether or not they're happy with that? I know that the defense attorneys had said that they needed it to be pretty specifically crafted.
Yes, and at first, if you got a chance to hear Clint Rucker, who's been the head DA, he conferred, I believe, with Paul Howard, who is the main DA, about some of this. And it seemed at first that they wanted to see if they could just get an instruction about continuing deliberations. And it seems that the defense really wanted them, if you're going to go that far, you might as well do the Allen charge. So I think in the beginning, prosecution didn't really want the Allen charge in a sense, but now that we're getting it, it's going to be interesting sitting there after this lunch break and seeing if whether or not the jury comes back with something.
Yeah, it was interesting to say the least. You know, it occurs to me as we talk about this that the person who's probably the most stressed about all of this is the judge. Because these issues right now are really oftentimes appellate issues. They become major appellate issues. The decisions he's making right now oftentimes are the most important ones. Latonia, do you know this judge, and do you have a sense of whether he's a pretty cool?
I do, actually. I know all of the parties in a sense on some levels. Judge McIver is very, very learned. He used to be a prosecutor in the Fulton County DA's office. He also was a U.S. attorney before becoming a judge and before coming back to the Fulton County DA's office. So he's very learned, very smart, very quick. And so he has been very diligent in doing his research and also conferring with both sides. I don't think either side feels that they have been given exactly what they wanted, but on some levels feel like they are getting what they need.
Yeah, and that's a good judge. When everybody leaves a little bit dissatisfied, it means that the rulings have been sort of down the middle. Nicole, I want to talk to you about something that just occurred to me as well. The judge has sort of, with this particular issue of this charge and how to give it, has really tried to get the two sides to agree upon a charge rather than make a ruling. And there's a reason for that, right?
Oh, absolutely. If you can get both sides to agree and there's no objection, then you haven't made a mistake. The courts of appeals look at these cases in terms of whether or not there was an objection to preserve the error. You sometimes hear that phrase, was the error preserved? And what that means is, did anybody complain during trial that what the judge was doing was somehow incorrect? And oftentimes, if there's no complaint, unless the error is very egregious, the courts are going to leave it alone. So a smart judge will sort of try to wind around until he reaches a point where both sides agree with whatever it is he's doing. And that's what he tried to do in this case.
Right. I mean, it is a smart judge, and it's a smart move. Anytime that you can get people to agree, it's helpful. Ladies, I'm going to let you go for the moment because we are going back to the great courtroom, that courtroom where we just left to see the first witness. Latonia, thank you so much for calling in. Your insight is really helpful. Nicole and Jonna, I loved having you here during the break, and I'm sure I'll see you again soon.
Great. Thank you.
Thanks, guys.
Thank you.
All right, we're taking you back live to that courtroom. We're going to see who the first witness is in this case of Ohio versus Grate.